Welcome to another episode of The Crypto Exchange, a Troutman Pepper podcast focusing on the world of digital assets and payments. As longtime leaders in the intersecting worlds of law, business, and government relations, our lawyers can go beyond the buzzwords and headlines to make sense of the emerging legal and regulatory frameworks for operating in the digital asset and payment industries. My name is Keith Barnett. I am one of the hosts of the podcast and a partner at Troutman Pepper. Before we jump into today's episode, let me remind you to visit and subscribe to our blog, consumerfinancialserviceslawmonitor.com. Don't forget to check out our other podcasts on troutman.com/podcast. We have episodes that focus on trends that drive enforcement activity, consumer financial services, the Fair Credit Reporting Act, cybersecurity, hot button labor and employment law issues, and more. Make sure to subscribe to hear the latest episodes. Today, I'm joined by my colleague, Deborah Kovsky, to discuss bankruptcies involving crypto exchanges. Deb, I'm looking forward to our discussion today.
Well, Keith, thanks so much for having me on. I really appreciate it. And I think there's a lot of really interesting issues that are coming up and that are going to be coming out of these bankruptcies that have filed, and probably new bankruptcy law and areas of law that are very unsettled currently.
Well, it seems like we have a new show on the horizons called, instead of Whose Line Is It Anyway, it's going to be Whose Crypto Is It Anyway? That seems to be the trend. And I say that because there's been a lot of attention paid recently to the question of who owns digital assets on a cryptocurrency exchange if the exchange files for bankruptcy. For example, we know Coinbase filed a 10Q for Q1 of this year, and Coinbase made the following disclosure, which it said was required by the SEC. And I'm quoting here, this is very interesting. Because custodially held crypto assets may be considered to be the property of a bankruptcy estate, in the event of a bankruptcy, the crypto assets we hold in custody on behalf of our customers could be subject to bankruptcy proceedings, and such customers could be treated as our general unsecured creditors. Close quote. And in fact, we've seen in recent bankruptcy filings by cryptocurrency exchanges that the debtors are taking the position that at least some of the digital assets on their platforms belong to them and not their customers. So Deb, how does this happen, and what should customers and investors be aware of?
These are great questions, Keith. I want to back up for 1 second and just clarify what's meant by property of the estate and why does that matter? Because it's a little bit of a term of art that not everybody may be familiar with. So a debtor goes into bankruptcy and all of its interests in property become part of this fictional legal entity called the estate. And the estate is subject to the automatic stay, so creditors can't get at it. If the coins are determined to be property of the debtor's estate, not only are they subject to the automatic stay, but they could be used to satisfy the debtor's general creditors and not just the depositors who put the coins there. So if you imagine, let's say I put 100 coins on a crypto exchange and filed for bankruptcy, and they've got creditors that are owed thousands or millions of dollars, and those 100 coins are all the assets they have. If that's property of the estate, they can take my coins and divvy it up among all of the creditors, and I'm only going to get back a small fraction. This probably came as a pretty huge shock, notwithstanding some public disclosures about it, to most depositors on crypto exchanges. And how this happens is you really have to delve into and look at the specific terms of service or terms of use for different accounts and different services on these platforms. You may have a scenario where an exchange has terms of service. These are click wrap agreements. These are the things that none of us ever read. We scroll down, we click the button, we go forward because this is a safe investment, right? Why do I have to read the detailed minutia of all of these terms of service, these terms and conditions? But if you delve into them, they may say things like, when you put your coins on this platform, you're making a loan of those coins to the crypto exchange. You are giving up all of your rights of ownership. The exchange has the right to trade those coins, stake them, hypothecate them, rehypothecate them, do all kinds of things with them. Use them as collateral for loans in its own name. And you have all of these terms of service and terms and conditions that people have literally never read or even thought about. And they usually don't matter until something goes seriously south, like in a bankruptcy case. So then they go into a bankruptcy and all of a sudden they're taking the position based on, and I'm not suggesting right now that I have any position or any insight into whether these types of terms of service would be enforceable, but they certainly give the debtor an argument that, in fact, coins that are subject to these types of contractual arrangements have been given over to the debtor and are no longer the property of the depositor. And the depositor just has a general unsecured claim, which is not a very highly ranked priority claim.
It seems to me, at least in the banking industry, you have FDIC insurance, and in the securities industry, you have SIPC. Is there any type of crypto insurance that the crypto exchanges have?
Certainly not anything that's regularized and broadly used. And making the analogy to banks is a really good analogy because, if I deposit my money in a bank, I'm really lending my dollars to the bank. The bank is going to go out and do whatever it does with my dollars to generate returns. I might earn a little bit of interest in exchange. And when I go to withdraw my money, I'm not withdrawing my same dollars. I'm withdrawing a like amount from the bank. And the difference is, if the bank goes into some kind of a dissolution or liquidation, I have FDIC insurance to cover me. I get made whole, at least up to the limits. Same thing with stockbrokers that are insured under SIPC. You have protections in regulated industries that you don't have with crypto. And what's really interesting is 3 months ago, if you went on social media and any of the spaces where people who invest in crypto congregate, you would see all kinds of statements about the government needs to stay out of this, regulation is bad, the SEC is bad, the Fed is bad, and they're all bad until something goes seriously sideways and you realize, gosh, maybe some form of regulation is needed to protect people from what's otherwise the wild, wild west.
That makes sense because I know in some states they require crypto exchanges if they are holding consumer wallets that have cryptocurrencies or virtual funds. They will require them to register as money transmitters and go through the license and bonding and insurance requirements there. And that can sometimes protect the consumers. But let's move on. Let's talk about bankruptcy eligibility. We have some questions about that. How can cryptocurrency exchanges file for Chapter 11? Because if exchanges are effectively buying and selling securities, wouldn't they be required to liquidate under Chapter 7?
Really good question, and one that I think is going to be debated as more of these exchanges are likely to face the pressures of potentially trying to reorganize. You're absolutely correct. So if a cryptocurrency exchange is deemed to be a commodities broker or a stock broker, there are specific provisions under the bankruptcy code that bar them from accessing Chapter 11 and instead force them to liquidate under specific subsections of Chapter 7. One of the questions is, let's take the stockbroker example, just to talk about it theoretically. In order to be deemed a stockbroker, an entity would have to be active in effectuating the trades of securities and would have to have customers. And you'd think that customers would be a really intuitive thing to have if you're buying and selling and effectuating trades of securities. Surely there must be a customer on the other side, but it's actually a pretty specialized bankruptcy term. And a lot of the litigation in prior cases over whether various entities outside of the crypto universe were really functioning as stockbrokers has revolved less around whether is the product they're trading a security versus do they have somebody that qualifies as a customer under the specialized bankruptcy definition. It's not clear whether these cryptocurrency exchanges would qualify. Certainly, there have been state regulatory actions that have indicated that at least some of the products that these exchanges are offering, if not the actual crypto itself, but the way that the exchanges are packaging products and enabling cryptocurrency to earn rewards on their platforms, that type of account or that product itself is the security that's being offered or sold. If there's the argument that, okay, at least something that they're doing is effectuating trades of securities, and if there is an argument that the individual retail depositors qualify as creditors for buying and selling and trading these securities. It's one of those, if it walks like a duck, quacks like a duck, at some point you're going to have to conclude it's a duck. Then these exchanges may not have an option to reorganize. Their only option may be to liquidate. And unfortunately, the liquidation under the bankruptcy code is different from a SEPA liquidation because there's no SIPC insurance. So the holders of these securities have no insurance to look to make them whole. They just have whatever assets are left on the platform.
Wow.
Again, question about whether there should be more regulation in this space or if we're going to end up seeing a lot of Chapter 7 liquidations.
It seems like that is something that, I guess, as a matter of first impression, in some instances, the courts are going to have to work through.
Interesting point. Yes, if somebody brings it up, because there may be broad consensus, at least with the exchanges that have filed right now, maybe we don't touch this with a 10-foot pole before we see whether there is an ability to effectively reorganize, because if that's going to get creditors a better return, then everybody's just going to leave it alone. If at the end of the day, it looks like, gosh, we just spent $100 million on professional fees in Chapter 11. And by the way, Chapter 11 is really expensive. And maybe $100 million is a high estimate, but it's not completely out of the ballpark of what might be reasonable in a very large case. You're going to spend tens of millions or even $100 million on professional fees. You get to the end of the day and you haven't achieved any better of an outcome for the depositors who put their money on the exchange or other creditors. Folks in the next case might look at it and say, you know what? We think that we'd be better off financially at the end of the day if we actually said, you know what, let's not even try to go down that route because it's too uncertain, too expensive. And at the end of the day, we're not even going to do any better. Let's just liquidate right now at the front end. And then somebody will bring this argument up and will push it in front of a court and we'll see how it comes out.
And speaking of depositors, what are clawbacks, and should depositors on crypto exchanges be worried?
I would say yes, they should be worried, and here's why. Clawback is sort of a colloquial term for Chapter 5 causes of action. So avoidance and recovery claims that can be brought under Chapter 5 of the Bankruptcy Code. These are typically preference actions and fraudulent transfer actions. And fraudulent transfer, don't get confused by the name, often has absolutely nothing to do with fraud. It's a type of transfer that often is just constructively fraudulent or is voidable because the recipient got something and didn't give reasonably equivalent value in exchange. These are the kinds of claims where it's like the bankruptcy code is kind of rubbing salt in the wounds of creditors. Take a preference claim. If a depositor got coins out of a cryptocurrency exchange within the 90 days before its bankruptcy filing, and that enabled them to do better, and they got more out of it than they would have gotten had they not taken those coins out, and instead the crypto exchange had liquidated under Chapter 7, very low bar to meet, then that is potentially a preference. And that can be potentially clawed back. In fact, there was a cryptocurrency exchange that filed 2 years ago, and now is just about the time that the post-confirmation liquidating trustee is sending out demand letters to the depositors, the ordinary folks who put their coins on the exchange and then took them off in the 90 days before the bankruptcy. They're getting demand letters from the trustees saying, hey, remember when you withdrew your coins and you thought you were so lucky to get out in time? Actually, we want back the value of those coins at the time. And remember, crypto was doing much better 2 years ago.
Wow.
It's definitely a cause for concern, but I also don't want to be too dire here because there's also defenses. And I think the defense that is most likely to get litigated in these cryptocurrency bankruptcies is the 546E safe harbor defense. Because if these things are securities, and again, some state regulators have said, yeah, these look like securities, they act like securities, we deem them to be securities, okay, fine. Well, Section 546E of the Bankruptcy Code protects the settlement of securities transactions from being clawed back by the debtor in possession or trustee. The whole point, the public policy behind it is to protect the integrity of these markets. And it's really the commodities markets and the securities markets. But you know what? The cryptocurrency market is one of the emerging markets that really functions very much like a securities market or a commodities market. And the same public policy implications, I think, are invoked here as well, where there could be a defense to say, look, This was, in effect, the settlement of a securities transaction. And in order to protect the integrity of this market, this is really safe harbored under 546E. So sorry, you can't claw any of it back.
That's interesting. And another question I have is, how are security interests in cryptocurrency perfected? And why does that matter in a bankruptcy?
That's something that's definitely going to matter a lot to the debtors themselves and more derivatively to creditors, because it's a way that the debtor may be able to go out and look for clawbacks against other entities where it can bring money back into the estate that can then help satisfy its ordinary retail creditors. So what does that mean? Let's say that you have a cryptocurrency exchange that one of the ways that it was generating returns, it was taking out loans. And it was going to use those loans for other purposes. But in order to get a loan, the exchange didn't want to sell the crypto that it was holding, so it collateralized the loan. The crypto exchange sends 100 Bitcoin over to lender, and lender lends, say, 100 USDC to crypto exchange. Now that collateral is sitting over there. And that lender says, hey, I'm a fully secured lender here. I've got this collateral. I'm totally protected because also the Bitcoin's worth quite a bit more. But then Bitcoin drops and it falls below the LTV that was required for the loan. And the lender says, you know what, I'm just going to go ahead and liquidate the collateral. I'm going to pay myself off and you, crypto exchange, are going to take a loss. What if it turns out that that lender didn't properly perfect its security interest in the collateral? If that were true, then the debtor, which has the rights of a trustee under the bankruptcy code, and the trustee has the rights of a hypothetical lien creditor, the debtor can go and try to avoid that transaction and say, you know what, give that all back. And now you're just, instead of being a secured creditor, you're just going to be a general unsecured creditor. And you're going to have to get in line with everybody else. And instead of getting paid 100 cents on the dollar out of what you thought was your collateral, in fact, you're only going to get paid 60 cents on the dollar, 20 cents on the dollar, whatever the rest of the unsecured creditors get. And the question is, how was that supposedly secured lender supposed to perfect its security interest in crypto? And the reality is there was no clear answer under the UCC. Cryptocurrency, just, if you look at Article 9 of the UCC, which governs secured transactions, it just doesn't work. The only category that seems to apply is sort of the catch-all bucket for general intangibles. A security interest in general intangibles are perfected by filing a UCC-1 financing statement. They are not perfected by possession. And I am pretty sure that almost everybody who has taken crypto and had possession of it as a quote-unquote secured creditor has believed they were properly perfected because they had possession. How can you possibly be better off than actually having the stuff in your control? You know, you got the keys. It's your keys. It's your crypto. And yet, if you look at the Uniform Law Commission, which just passed their new Article 12, which deals with digital assets, and they're amending Article 9, none of which has been adopted in any state yet. But there's some really interesting comments that they made in their overview to the 2022 amendments to the UCC for emerging technologies. And one of the things that they said with respect to security interest in digital assets, they said, under the prior version of Article 9, there was no effective way for a lender to perfect a security in digital assets except by filing a financing statement. I think that's a really interesting statement for them to make because on the one hand, you could make the argument it wasn't clear under the prior Article 9, so we're going to look to the new amended Article 9 that comes out in 2022, and we're going to argue to courts to say, look, Judge, you should really look at it the way that it's going to be under the amended Article 9, where possession would be the way that you perfect in digital assets. Or alternatively, you can say, no, Judge, clearly this is a sea change in the law, and that prior to 2022, the only way that you could perfect in digital assets was by filing a UCC-1 financing statement. And if you didn't do it, then you didn't perfect. And that could have huge billion-dollar implications in these bankruptcy cases.
Wow, this is all very, very interesting. You gave us a lot to think about, a lot of things to unpack here. This has been great. Deb, thank you for joining us today.
Oh, totally my pleasure.
Now, this was very excellent discussion. And also thank you to our audience for listening to today's episode. Don't forget to visit our blog, consumerfinancialserviceslawmonitor.com, and subscribe so you can get the latest updates. Please make sure to also subscribe to this podcast via Apple Podcast, Google Play, Stitcher, or whatever platform you use. We look forward to the next time. Thank you.
Copyright Troutman Pepper Hamilton Sanders LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Pepper does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including, without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper. If you have any questions, please contact us at troutman.com.